rise to speak to the merits of S-2, an act which may be cited as the Protecting Victims from Sex Offenders Act. Mr. Speaker, this legislation proposes to enhance the current provisions respecting the registration of information relating to sex offenders. As Audible members will know, and we've heard some debate here this afternoon, this is an extremely important bill, and a bill that deserves our utmost attention, as it deals with ensuring the safety of our children and other vulnerable Canadians from sexual predators. Mr. Speaker, as you know, public safety is an objective shared by all parliamentarians, both here and in the other place where this bill originated. Moreover, Mr. Speaker, S-2 carries on initiatives undertaken by all premiers and all territorial leaders in concert with the federal government, calling for a national sex offender registration system. A bit of history, Mr. Speaker, if you will. As early as 1997, the principal features of a registry were thoroughly discussed by all of the ministers responsible for criminal justice in their own provinces, the federal government, and all territorial jurisdictions. And their endorsement led to the Sex Offender Information Registration Act of 2004. Indeed, Mr. Speaker, Bill S-2 reflects and continues a national consensus that responds to a concern shared by all Canadians. Mr. Speaker, since forming government in 2006, we have taken a series of actions to better protect Canadians from sexual abusers, and we will continue to do so. But I would like to reiterate that the legislative foundations for this bill we are considering here today stood out as a wonderful example of what can be accomplished when federal, provincial, and territorial interests are accommodated through consultation and cooperation. I should also mention that this bill has the support of law enforcement, prosecutors, and victims of advocate groups. Mr. Speaker, Bill S-2 has been reported by the Senate Standing Committee on Legal and Constitutional Affairs and was previously examined by the Parliamentary Standing Committee on Public Safety and National Security, of which I am a member, as Bill C-34 in the last session of this Parliament. This legislation reflects input from a number of sectors, including corrections, law enforcement, child protection agencies, and victims groups. The Senate Committee provided a forum for a thorough discussion of a range of views and positions regarding the efficacy of a national sex offender registry. I would submit, Mr. Speaker, that this is a strong indication that the government's proposals were a fitting response to urgent suggestions that the sex offender database be more inclusive. Mr. Speaker, these multi-sectoral consultations that I refer to led to the significant amendments that have been before the legislative drafters for some years. Discussions have covered the viability of the registries and have monitored the implementation of the Act. Perhaps the most pressing question in this debate has been that of arriving at a balance between limiting or increasing the scope of the registry. The question becomes what parameters should govern the numbers of offences and which offenders ought to be included in a registry. Also, questions that need to be resolved and have been resolved by these amendments are how long should a registration order remain in force, who should determine if and when an offender should be registered. In other words, Mr. Speaker, once a list is begun, where should it end? These questions were pivotal to the establishment of the National Sex Offender Registry, and experience gained by criminal justice practitioners can now be applied to better balance public safety and the human rights in this legislation. At the time of its inception, Mr. Speaker, the only sex offender registry in Canada was maintained by the province of Ontario. Aspects of that registry were then being contested in the courts, and we now have the benefit of a number of judicial decisions. Accordingly, our government has drafted legislation that is responsive to public safety concerns across the country while achieving a balance with concerns about fairness and also with human rights. Although, Mr. Speaker, you need no education in the area of criminal justice, please allow me to refresh the memories of those present when the National Registry was created and to provide background for more recent arrivals. The initial legislation, which I refer to, the starting point for the legislative changes we are considering today, proposed a registry that was to have included only those convicted of designated offences after the legislation came into force. However, during review by Parliament, the registry was amended to include offenders previously convicted of scheduled offences who were as of the date of coming into force, either incarcerated in a provincial or federal institution, or B, under a conditional or intermittent sentence, or C, on probation or parole. Mr. Speaker, also included are those offenders under a detention order or who had not been absolutely discharged subsequent to a finding of being, quote, not criminally responsible, unquote, for that offense. This latter inclusion stems from the fact that while a disposition by a court that an offender is not criminally responsible means that there has been no finding of guilt, it is still a finding that the offender committed the offense. For reasons that are apparent, Mr. Speaker, it was deemed desirable to keep this class of offenders within the registration scope of the Act. Parliament has heard from a number of sectors regarding registration and made appropriate amendments. The registry's effectiveness has been monitored through the implementation period. With the benefit of this experience, Mr. Speaker, the government believes that the time has come to ensure a more rigorous approach. So the final outcome of our efforts here today ultimately focus on the central concern of all involved, the safety of Canadians from exploitation and crime. Protection from sexual predators, Mr. Speaker, is the raison d'etre of this legislation. Briefly, Mr. Speaker, I would like to touch on the main features of Bill S-2. To reinforce what others have mentioned, the key provisions is that registration under both the Sex Offender Information Registration Act and the DNA Identification Act would become automatic upon conviction, making it mandatory for the sentencing judge to impose an order to register and provide a DNA sample whenever a conviction for a scheduled sexual offense has been entered against the offender. The Crown Prosecutor will no longer be required to bring an application for an order. This legislation, Mr. Speaker, will empower police to take action if they detect suspicious activity on the part of a registrant, even if no overt criminal activity is underway. Prevention becomes possible that was previously beyond the scope of the law. And certainly in committee, upon examination of the former C-34, we heard anecdotally and otherwise of many instances when Crown prosecutors wouldn't ask the court for an order of inclusion on the registry. Some of this was a matter of plea bargain. Occasionally it was a mere oversight. But in any event, under the proposed legislation before this House, the Crown will no longer be required to bring an application. Such inclusion will be automatic, and I think all members will agree that that is a change that's worthy of their support. Furthermore, Mr. Speaker, police will be able to identify registered sex offenders who are traveling to other jurisdictions, both domestic and internationally. Again, a level of prevention is made possible by these amendments. In addition, corrections officials will be able to notify police forces of both the release and the readmission of registrants. Finally, and just as important, the registry will be enhanced by the inclusion of vehicle data to assist authorities in monitoring, investigating, and if necessary, prosecuting registrants where necessary. So to sum up, Mr. Speaker, for all members of the House, the development of Bill S-2 sets out a framework for continuity in a cooperative effort among federal, provincial, and territorial governments. Significantly, this is a national system, unlike the efforts elsewhere where duplication and confusion may reign. We have the advantage of a single, common approach that combines the efforts of various criminal justice sectors, but at the same time respects the provincial role in the administration of the system. Mr. Speaker, the additional measures we will be passing in this House after due consideration will further simplify, unify, and strengthen efforts to protect the vulnerable among us. It must be recognized and must be emphasized, Mr. Speaker, that these goals will be achieved while respecting both the needs of law enforcement, the courts, and the civil liberties of all Canadians. In that regard, Bill S-2 is an undertaking to improve earlier legislative efforts that, although well-intentioned, have proven to be less than comprehensive. In this, Mr. Speaker, we have benefited from the experience, expertise, and the goodwill of many sectors within the Canadian criminal justice system. I believe that we can move this matter to a timely conclusion. I understand that there is support among all members of the House, or the majority of the members of this House, to pass this bill at second reading and to send it to the Public Safety Committee, in which myself and all of the members will give it a thorough examination. And accordingly, I urge all honourable members to speed the passage of this important bill. Canadians have asked for it. Victims of crime deserve no less. Thank you, Mr. Speaker.